Second Amendment Foundation founder Alan M. Gottlieb was rejoicing Friday after a federal appeals court ruled the Constitution does not give authority to officials in the District of Columbia to decide whether a gun owner has a good reason to need a concealed carry permit. "We are grateful," he said, "that the court has shown considerable wisdom, and this should help advance the effort to assure reasonable concealed carry for district residents. It represents one more advancement in our effort to win firearms freedom one lawsuit at a time." It was the U.S. District Court of Appeals for the District of Columbia that turned down a demand from the city from the full court to rehear the case Wren v. District of Columbia. SAF revealed not a single judge on the court requested a rehearing. This infallible argument for armed self-defense presents real stories of Americans fighting back against criminals, and surviving because they were armed. America Fights Back, Armed Self-Defense in a Violent Age is a must-read for anyone who has ever wondered if concealed carry can actually save and protect. The earlier decision from a three-judge panel there came down in favor of Brian Wren and SAF, who had challenged the district's practice of demanding that citizens provide a good reason to be issued a concealed carry permit. Authorities there then reviewed and decided whether or not the reason was good. But the court panel struck that requirement. 10 years ago, Washington, D.C.'s political leadership tried to extinguish Second Amendment rights before the Supreme Court, said Alan Gura, the famous attorney who has fought many gun rights battles in the nation's courts. The result was D.C. v. Heller, a tremendous victory for the rights of all Americans. With the Court of Appeals again confirming the people's right to bear arms, Washington, D.C.'s politicians must once again ask themselves whether it makes sense to keep resisting our fundamental rights. He was the lawyer to one at the Supreme Court in both the 2008 District of Columbia v. Heller case and in 2010 in the McDonald v. City of Chicago. Heller affirmed that the amendment protects an individual right to keep and bear arms, and McDonald incorporated the Second Amendment to the states via the 14th Amendment. SAF explained. The district imposed the good reason rule following its earlier gun control fight losses in court. The D.C. government had petitioned for the full court to hear the current case, but the judges refused to reconsider the 2-1 decision that came earlier this year. The Washington Times suggested the result sets up the potential for the Supreme Court to take up the case as the decision creates a split with 4 other federal circuits that have found discretionary permitting schemes elsewhere are legal. Adam Winkler, a law professor in Los Angeles, told the newspaper, because of what the D.C. Circuit didn't do today, the Supreme Court is now far more likely to take a concealed carry case. The result could be a nationwide precedent for access to concealed carry permits. Carl Racine, the Attorney General for the district, said he was reviewing whether there would be a further appeal. Technically, the city had demanded that gun owners to prove they have a good reason to fear injury or another proper reason to have a permit. Officials described qualifying circumstances as having a job that requires carrying large amounts of cash or something similar. WND reported just weeks ago the now banished rule had allowed Police Chief Kathy Lanier to deny 99% of all carry applications. Officials in Washington also had claimed their city was unique because of its dense population, which includes thousands of high-ranking federal officials and international diplomats. The majority opinion in the July ruling was written by Judge Thomas Beale Griffith, a 2005 George W. Bush appointee, who declared at the Second Amendment's core lies the right of responsible citizens to carry firearms for personal self-defense beyond the home, subject to long-standing restrictions. The district's good reason law is necessarily a total ban on exercises of that constitutional right for most D.C. residents. That's enough to sink this law under the 2008 U.S. Supreme Court's Heller ruling. Larry Pratt, executive director of Gun Owners of America, told WND in July that the D.C. law was a de facto gun ban that affected all law-abiding people who visit the nation's capital. Overturning the de facto D.C. gun ban on constitutional grounds is very welcome. Not only does it respect the Constitution, it will result in fewer crimes of violence in the district, he he said. This infallible argument for armed self-defense presents real stories of Americans fighting back against criminals, and surviving because they were armed. America Fights Back, Armed Self-Defense in a Violent Age is a must-read for anyone who has ever wondered if concealed carry can actually